Hi viewers, we are going to discuss about the appeals chapter today of the civil remedies, and this is the part of CPR rules 52. So there are two types of court actually, the appeal court and the lower court. Appeal court means the court to which an appeal is made, and the lower court means the court or judge from whom a decision has been made, and we are going to appeal against that's decisions or judgment. Council's roles as a counsel or an advocate or barristers, we are playing four types of role in this regard. First of all, advising, seeking permissions, settling documents, and conducting the appeal. Advising means that we are, as a councils, we need to take a short note at the end of the judgment that the prospectus of success, prospective, how much probability do we have if we appeal in the next court, upper court, the chances of success. And the second permissions, remember to try the court of first instance. We will deal with the reasons why in detail below. So we can seeking permission from the lower court as well as the appeal court. We have two chances. So if we want to do the appeal, then we can take the chance at the lower court, at the first court of first instance. So that will give us two chances at the two bites in the same bread. So settling documentations, notice of appeal, skeleton judgment, advice on bundle. So many works we have to do for prepared our appeal applications, and for these reasons we need to serve the notice appeal, and we need to make an skeleton arguments why the appeal is possibly unreasonably acceptable, and the grounds of the appeal and judgment. We need to add just attest the judgment of the lower court, and find the factual and legal disputes, which is not which is actually the main grounds to grant the appeal. And they finally we need an advice on bundle conducting the appeal. So if you are acting on behalf of the appellant, you will start, even if you were the defendant who will appeal, and as an appellant, he must start first. So not an appeal, which applications are will not be an appeal. There are so many applications we are doing in the procedures and the court procedures, and all of them are not regarded as appeal. Suppose, remember that some situation the appropriate course is to go back to the court which made the order, like where case management decisions are made by the court without a hearing, and one party wants the court to reconsider. So if the court will reconsider that the other party has not been present while the court procedures were taking place, and the learned court has to take into the consideration the situation. This is not an appeal. Where an orders includes a liberty to apply, like Tomlin order. This is not an appeal. Where a respondent seeks to vary or discharge an interim injunctions. So some conditions will be ups and downs, and maybe set aside, or some changes must may be brought, in that case in interim injunction, that will not count as an appeal. So rules of appeal, we have some decisions from different courts to different uh, uh, upper court, and that will be has specific rules. The crown court circuit judge go to district judge go to the crown court circuit judge, crown court circuit judge, or the high court masters. The decision from these two courts will go to the high court judge. High court masters and district judge may be appealed to the high court judge, and crown court circuit judge decision may be appealed to the high court judge. High court judges may be appealed to the court of appeal, and to court of appeal may be appealed to the Supreme Court. So crown court district judge may be appealed to the crown court circuit judge. Crown court circuit judge may be appealed to the high court judge. High court masters and district judge may be appealed to the high court judge. High court judge may be appealed to the court of appeal. The court of appeal may be appealed to the Supreme Court. So this is the way we can go from lower courts to upper courts for the appeal decisions. There are some exceptions. Some people appeals from a county court circuit judge go straight to the court of appeal. Crown court circuit judge go straight to the appeal rather than the high court. the circumstances, there are some circumstances where this decision has been changed, and this is some we have some exceptional appeal system. A final decision made in a multi-track case of the if it is a bigger claim like multi-track claim, this does not apply to part 8 claims. They will lie to the high court masters in a usual way. So a multi-track claim, if it is a multi-track claim, then it will go straight to the high court from the county court circuit judge. So a final decision made in a specialist proceedings like part 7 a claim, but specialist proceedings, then it will go to the high court, where a decision by the county court circuit judge or high court judge was a second appeal which was heard from a lower court. The second appeal will go straight to the court of appeal. So আমরা যদি if we find that where the decision by the county court circuit judge or high court judge is itself an appeal, that means the lower court has given the orders. So the county court circuit judge or high court judge itself, and it was a second appeal which was heard from a lower court. The second appeal will go straight to the court of appeal. The only exceptions to this is appeals in part 8 claims. This follow the general rules of appeal set out above, even if they are a second appeal. If it is so we know about the part 7 claims and part 8 claims. Part 8 claims regarding the issues like injunctions and all other orders which is come from the other decisions, and the part 7 claims is straight the claims like contract, breach of contract, negligence, personal injury claims, all are part 7 claims. But injunction on some other orders which is not directly involved with the case, that will be count as a part 8 claims. So we need to take a clear idea about the part 7 claims and part 8 claims. Optional transfer to the court of appeal. Some court of appeal has some jurisdiction to hear the appeals applications. The circuit judge or high court judge, due to hear an appeal, has the discretion to order that it is transferred to the court of appeal. This will happen where they believe it passes the standard of court of appeal test. So maybe we apply it to the court of appeal or high court judge for the appeal applications, but these two courts judges have the power to uh, observe these appeal applications or appeal applications, and they can make an order that if the test appeals test has been passed by the case application, then they can send it to the court of appeal. What are the tests? There are two-step test. Two-step test. The appeal raises an important point of or point or principle of law or procedure, principle or procedures. That means the appeal raises an important point or procedures, principle or procedures, or there's some other compelling reasons for the court for the court of appeal to hear it. That means the lower court thinks that we are not capable to handle this issue, so we should transfer this case directly to the court of appeal. So uh, the circuit judge or the high court judge, due to hear an appeal, has the discretion to order. They have the power, discretionary power, whether they will hear it or they will transfer it to the court of appeal. So only the judges in the higher court, not the judge in the lower court where the original decision was made, has the power to make this decision. So permission to the appeal. So every appeals for every appeals applications or apply for the appeal, we must take the permissions from the court of first instance or the appeal courts. Permission is almost always required to bring an appeal. Permissions may be sought from the lower court or where the decision was made, or from the appeal court where the appeal would be heard. So two places. So if we apply in the court of first instance or the lower court where the decision was made, then we will get an extra chance to seek the permission of the appeal. Maybe we miss the chance of the lower court for appeal applications. Then we have only one chance, which is the appeal courts. If appeal courts reject my applications, then we don't have any other options. So if we take this chance at the lower court, then we will get two chances for the permission of the appeal. So the only situation where permission is not required or where a person's liberty is infringed. So every appeal, we need to seek permission from the court, but only one situations where we don't need any permissions to appeal where the liberty of a person is infringed, like a person is arrested and nobody is acknowledged his arrest, like DB or RAB in our country, that they have just arrest a person, take them away, and disappear. In that case, where the personal liberty of a person is infringed, in that case, we don't need to taking any permissions for appeal. Okay, the only situation where permission is a committal order. All those against all those orders we can apply without seeking permission. A committal order, a refusal to grant habeas corpus in the high court, especially we apply for that. A secure accommodation order, court officer's decision on detailed assessment. When a lower court refuses an application, a further application can be made to the higher court, appeals court. Applications for appeal are usually made orally at the lower court. At the end of the proceedings, it is always a good idea to do this, as it gives you two bites of the cherry. Okay, an application to the court of appeal can only be made with the permission of the court of appeal. If we apply for the permissions of the court to the court of appeal, then we need to apply to the only to the court of appeal, not in the lower court. But the decision was made in two situations. There are two situations when we need to apply for the court of appeal for seeking permissions of appeal applications, where the original decision was from a county court, where the appeal in from a high court decision, which was itself an appeal from an earlier decision. So in these two situations, we need to apply to the direct to the court of appeal, and only court of appeal can give us the permissions to for make the order, make the appeal. Okay, so where the original decision was from a county court, the original decision first at the first instance, it was taken place at the county court, and second, where the appeal is from a high court decisions, which was itself an appeal from an earlier decision, or that is mean it is a second appeal we are going to do for to the court of appeal, and first appeal was already hearing taken place in the high court. So sorry for disruption. We are making the okay, fine. So we are going so fast because it is already 12:33, 12 minutes already passed. So we are coming to the court of appeal, and this means where the decision was a first instance decision in the high court, permission can be granted from the either the high court or the court of appeal. Otherwise, permission can only be sought from the court of appeal. Okay, where the original decision was from a county court, the if we apply for the appeal decision, seeking permissions of the appeals, then we need to go to the court of appeal, and court of appeal is the only court who can give the permissions. And if the court first instance court was high court decision, and which was itself the first appeal, then the court of appeal is the court of second appeal. Then the court of appeal is the only court who can give this permission. So this is clear. Okay, the test for granting appeal, in this case, the test for granting appeal, an appeal in the first instance, two types of granting appeal and two types of test. The test is normal procedures. The appeal would have a real prospect of success if it is in the court of first instance. So in the first instance court, if we apply for the seeking permission of the appeal, then we need to pass this two stages test. First one, the appeal would have a real prospect of success, first one, and or there is some other compelling reason why the appeal should be heard. Appeal should be heard. Okay, there is some other compelling reason why the appeal should be heard. And appeals to the court of appeal, where the appeal is from a county court or where it is a second appeal from the high court, must pass a different test. Okay, so if we apply in the lower court, then we have to pass the two-stage test. The appeal would have a real prospect of success, and there is some other compelling reasons why the appeal would be heard. Appeals on the high court of appeal, where the appeal was from a county court or where it is a second appeal from the high court, must pass a different test. And the tests are: the appeal raises an important point of principles or practice, and there is some other compelling reason for the court of appeal to hear the appeal. So the clear distinction between these two tests for the court of appeal, if we apply in the court of appeal or the second appeal, appeals to the Court of Appeal, where the decision has come from the county court, or it is a second appeal from the High Court, must pass a different test. And the test is the appeal raises an important point of principle or practice. And second is there is some other compelling reason for the Court of Appeal to hear the appeal. Okay, procedure for application for permissions. What is the procedures? If the permission for appeal is refused by the lower court, time limit for appeal, it is only 21 days, and it must not extend beyond 35 days. So it is clear. Appellant's notice, file an appellant's notice within the time limit requesting permission to appeal. Okay, it must set out the decision of fact or law made by the court which it believes to be wrong or unjust. So appellant notice within the time limit requesting permission to appeal. We have applied to the court requesting the permission for appeal within time limit. And second one, it must set out the decision of fact or law made by the court which is believed to be wrong or unjust, and it must state why it believes the final decision was itself wrong or unjust. So we have to mention all these points in the appellant's notice and appeal bundle. An appeal bundle must be lodged with appellant's notice. This bundle includes skeleton argument, statement of case from original decisions, a copy of the judgment of the lower court, a signed certificate from the solicitor saying he understands his duties in preparing the bundle and has complied with them. So, what the papers or documentations we need to apply for an appeal? Appellant's notice and appeal applications. Skeleton argument must be needed, and statement of case from the original decisions. What is the case? And a copy of the judgment of the lower court. What is the decisions have been made by the lower court, and what is the wrong or unjust in the past decisions and the lower court's decision, and a signed certificate from the solicitors saying he understands his duties in preparing the appeal bundle and has complied with them. Okay, serve the appellant's notice on the other side. With this evidence, after it is filed with the court, the bundle must be served on the other side. The other side does not need to do anything else at this stage. So, if the applicants must serve all the documents to the court, and court within 7 days of the applications, they serve all the documents and necessary papers to the respondents. And decision of the application of the permissions to appeal. Decision of the application of the permission to appeal. I have applied for the permission of the appeal to the court. And what is the decisions? The appeal is usually considered without a hearing. The appeal is usually considered without hearing. After the considering all the papers and the written arguments and explanatory arguments, the court may take a decisions. And if permission is refused, they didn't give the permissions to apply, the applicant can request the matter to be considered at an oral hearing, at which he can make submission within 7 days of the refusal. Okay, without hearing, the court can refuse the application, but within 7 days of the refuse the applications, the applicant can get a chance for hearing in the open court, and an oral hearing, and the court can consider and they can make submissions within 7 days of the refusal. And after oral hearing, maybe the court can convince that, and they can give the permissions. Okay, if the judge at hearing considers that the application is totally without merits, she or he may make an order that the person seeking permission may not request for further reconsideration. Okay, after oral hearing, the court, if the court can find out that the application is without any merits, or he or she, the judge, may make an order that that further this candidate cannot make any further applications for reconsiderations regarding this case, that it is so meritless and so groundless that there is no point to accept the application for reconsiderations to the appeal appeal could be granted, or appeal were granted. Such a decision is final. If the permission is granted either by the lower court or by the appeal court, the matter goes to the substantive hearing. If the permission is granted by the lower court or the appeal court, then the court will the case will go for a substantive hearing. Substantive hearing of the appeal. For substantive hearing, the procedures to follow are almost identical on those for permissions to appeal. Sometimes hearing for permissions to appeal and the substantive hearing take place at the same time if permission granted. Appellant's rule: the notice for a permission needs to be served to the respondent. The respondent's rule: a respondent does not have to serve a respondent's notice if he wishes the original decision to be confirmed on the same grounds as those set out by the trial judge. Okay, the applicant's rule: in that case, the notice of permission needs to be served to the respondent. So I have got the permissions, and this notice must be served to the applicants to the respondent. Respondent does not have to serve a respondent notice if the wishes original decisions a decision to be confirmed on the same grounds as those set out by the trial judge. Respondent notice, but file the respondent's notice within 14 days of the deemed service of the applicant's notice of permission. If a respondent who wishes to confirm the decisions on additional or different grounds does have to serve a respondent notice on the appeal court, and a respondent who wishes to vary the decision, that means change the decisions, are considered to be appealing, and they will also have to serve a respondent notice. Serve the notice and the bundle to the applicant as soon as practicable, but no later than 7 days after filing. A respondent notice is very similar. So, respondent's notice, but file the respondent notice within 14 days of deemed service of the applicant's notice of permission if a respondent who wishes to confirm the decision on additional or different grounds does have to serve respondent's notice on the appeal court. That I have, as an applicant, I have additional or different grounds. As a respondent, then I must have to serve the notice to the appeal court, and as a respondent we wishes to vary the decisions are considered to be cross appealing. That we have also an appeal case, like we are not agreed with the lower court's decisions like the applicant, so we think that the higher punishment or higher fine should be confirmed, and our applications against the appeal will be considered as a cross appealing, and they will also have to serve a respondent notice, and serve the notice and the bundle to the applicant as soon as practicable, but not later than 7 days after filing. A respondent's notice is very similar to the applicant's notice. It gives the respondent's view on the contentious decisions of the judge and on the correctness of the overall decision. The notice will also be accompanied by a skeleton argument. So, respondent notice is very similar to the applicant's notice. It gives the respondent's view on contentious decisions of the judge and on the correctness of the overall decision. The notice will be accompanied by a skeleton arguments. So, composition of the Court of Appeal. Generally, the Court of Appeal is made up of 3 judges, but on the appeal from the county courts or masters of the high courts decision, they may sit as 2 judges. If they both disagree, either party may apply for a rehearing before a full court, which is usually not less than 3 judges. So, for a decision in the generally the Court of Appeal is made up of 3 judges. Okay, on appeals from the county courts or masters of the high courts decision, and the decision from the county court or masters of the high courts judges, it can be 2, but if they disagree, these 2 judges, yeah, with each other decisions against each other decision, they must be applied by the applicant or respondents for rehearing, and that rehearing must be before the trial, which will be consist at least 3 judges. So all other appeals will be heard by a single judge, such as first instance decisions, that any other appeals decisions made by a single judge. Okay, composition of the review or rehearing. An appeals will usually take the form of a review of the decision, not a complete rehearing or fresh trial. The court does have the power to approach the matter as a rehearing, but this is used very rarely. An appeal will usually take the form of a review, like we here take these procedures like a review hearing, and the decision not a complete rehearing or fresh evidence will not be acceptable directly normally, but in some cases maybe fresh evidence may be introduced or admissible if it is necessary for the interest of justice. So unless it is specifically orders otherwise, fresh evidence will not be here. This is a matter for the discretion of the court, but it will be done in accordance with the overriding objectives. Pre-CPR case law remains influential. This stated that fresh evidence could not be called unless it could not have been obtained with reasonable diligence for use at the original trial. It would probably have an important influence on the